Okay, now we are. Welcome everybody to this morning's session, June 14th, 2021 of the Kansas Court of Appeals. I'm Karen Arnoldberger, the Chief Judge of the Kansas Court of Appeals. And joining me on the panel this morning is Judge Catherine Gardner, as well as Judge Leslie Isherwood. We are happy to have her as our newest judge on our court. We are going to get started in just a second, but let me go over a few things first. You'll have 15 minutes to argue. The appellant will be allowed to reserve some time if they wish for rebuttal. Now, I see there are a lot of you on here today, so generally, just the people that are actually arguing are actually on screen. So are all of you going to be arguing, or has each side selected one person to do the argument?
Your Honor, excuse me, this is Jim Frickleton. I am the local counsel for the plaintiff side. So I wanted to be on video initially to introduce Kim Johnson, who will be doing the arguing for the plaintiff.
Okay, and so just one of you will be arguing though for the appellant?
Yes.
Okay.
And I'll turn my camera off as soon as you're done here.
Okay. And then what about for the appellee?
Judge, the same is true for me. I'm the local attorney for the appellee, and only one of the appellees will be arguing, and we can turn our cameras off as well when the argument begins.
So who will be arguing for the appellee?
Ms. Dubin will.
Okay.
Good morning, Your Honor.
Hi. And that was, I'm sorry, Ms. Dubin, and you were not on the briefs at all. Is that right? Okay, so, but you were admitted pro hoc vice too?
Yes.
Okay. I'm sorry, it's going to take me just a minute to get this down. Okay, so we should have a motion or something that's got all your law license numbers on it, right? And then,
yes, Your Honor.
Same with Kim Johnson. You were not on the briefs at all. Is that right? You guys are making
That's correct, Your Honor.
Okay. But you've also been admitted pro hoc.
Yes, I have, Your Honor. I was admitted 3 or 4 weeks ago.
Okay. Okay. With that information, let me tell you that we've read your briefs. And they're extensive in this case. So we know generally the facts of the case, so you don't have to waste any of your time really going over in extensive detail the facts, except of course the things you want to emphasize with regards to your argument. I will start out, and Ms. Johnson, did you want any rebuttal time?
Yes, Your Honor, please. I'd like to reserve 3 minutes for rebuttal.
Okay. All right. With that, then we will go ahead and get started. Appellant, you may, Ms. Johnson, you may begin.
Thank you, Your Honor. May it please the court. This court's ruling below, which dismissed the petition at the pleading stage, should be reversed. This court has unlimited review at the same standard that all facts pled must be accepted as true, all inferences drawn in the plaintiff's favor, indeed with every doubt resolved in her favor. And if she has stated a claim under any theory, and I believe she stated them under several, the ruling below must be reversed. As the court is well aware, this is about a so-called prescription pet food. The defendant, we allege, in a trust or conspiratorial combination with other manufacturers of similar food, as well as veterinarians and retailers, sell this fake prescription product. And the defendant coined the term prescription diet and sells this product, uses that trade name on its product to sell cat and dog food that we allege includes an inference of medicinal or disease-treating effects. And it uses that inference, that misleading inference, to sell this food at a premium price. But the reality is that neither the prescription pet food nor any of the alleged disease treatment claims have been evaluated, let alone approved by the FDA or any Kansas official, for safety or efficacy.
Ms. Johnson, let me ask you a question. If it weren't being sold at a higher price and the price were the same, would you still have the same causes of action?
That's a good question, Judge Gardner. The damages, there might not be substantial damages if there weren't a premium price for this food, so that the claim might be lessened. But the reality is still it's misleading to the consumer, and a reasonable consumer seeing the term, prescription or RX being told by a veterinarian this is a prescription product, is going to believe that there is an implication, an inference, a strong inference that some governmental authority has reviewed this product, found it safe and effective to treat whatever problem the pet is having. So I believe there still would be legitimate claims, although the damages, as you point out, would certainly be lessened.
Thank you.
Thank you. The error in this case, I believe, came from truly misconstruing the facts. And the court below, seemed to ignore a lot of the plaintiff's allegations and, minimized, trivialized, and almost disregarded them, and centrally refused to credit the key fact. And that is that the term prescription and the term RX, carry with them an indication of medicinal or drug properties. And that a reasonable consumer would believe that designation, that implied approval would justify a premium price. It's interesting because the very first sentence of the court's legal analysis in the ruling below, contends that the plaintiff claims that only other co-conspirators have websites with direct-to-consumer advertising, as to this prescription pet food, completely overlooking, paragraph 62A of the petition, which explains exactly what Hill's website says about its prescription diet, pet food, and directly to consumers, telling them to ask their veterinarians about it. This misconstruing of the facts, I believe, led to the errors of law and determined that there was no deception as a matter of law and that the veterinarian somehow broke the causal chain. And in doing so, the court seemingly gave talismanic or magical properties to an FDA compliance policy guide, which on its face says that it's non-binding. The top, front and center in bold, italicized, every page says, this contains non-binding recommendations. There's a boxed warning, equivalent to a boxed warning that you'd see on a prescription drug at the beginning of page 3, where it begins the substance of the recommendation. And it says, this does not establish any rights for any person and is not binding on the FDA or the public. FDA's guidance documents do not establish legally enforceable responsibilities, and they instead simply describe the agency's current thinking on various topics and should be viewed only as recommendations. The other thing that's really odd about this opinion, and I know that the court below was not writing on a clean slate. Before this case was filed, there were 2 other cases about prescription pet food, one filed in California, one filed in Illinois. And the district courts in those cases dismissed the claims. And that is where it stood when this case was filed. However, before the court below issued its ruling, relying so heavily on what it termed the persuasive authority of the Illinois trial court opinion, the Court of Appeals, the sister Court of Appeals there, reversed that opinion And it's very odd that the court below didn't even acknowledge that reversal. The opinion was sent to them, it was argued on the motions hearing, but somehow it was simply disregarded, forgotten, ignored. I don't know. I understand that they're only persuasive authority when it comes to interpreting the KCPA under Kansas law. But as the court below noted, there's very similar claims, very similar laws. I think he said at one point, identical claims.
Let me interrupt you for just a minute if I can, because I know you have a limited amount of time and there's some information I really want to talk to you about. The two cases, the Seventh Circuit case and the Ninth Circuit case, had claims similar to our Kansas Consumer Protection Act. There were no claims similar to the Restraint of Trade Act that I was able to see in those two cases. Is that right? There wasn't an allegation of monopoly and price fixing and the kinds of things you allege in this petition. Is that right?
Your Honor, I honestly do not know about the Illinois case. I agree with you. The Seventh Circuit opinion did not address that.
Right.
My firm and my co-counsel were not involved in that case. In the California case, however, we did raise antitrust act claims, federal claims, and those were dismissed, and that was affirmed in a separate opinion by the Ninth Circuit.
Oh, okay. Thank you. And why don't you tell me, because I'm having a hard time in reading the petition and understanding Hill's role in this restraint of trade allegation. I mean, I certainly see lots of allegations about kind of this incestuous relationship between PetSmart and Banfield, but I'm having a hard time figuring out how Hill's, who's simply a company that's allowed to, that's got a contract with PetSmart to sell its food in PetSmart stores, what's your allegation, what's your claim as to how it colluded with them?
Yes, the contention is that there's a specialty submarket for this prescription pet food,
Right.
and that the manufacturers colluded together to agree that they would require a prescription to be presented for it to be purchased at retail.
But Hill had that. To purchase at retail. That's your distinction.
That's the distinction on the antitrust claim.
Okay, so before this, are you saying Hill's only became available at retail when it entered into the agreement with PetSmart?
I believe it was. I'm not certain of the timing, honestly, Your Honor. We've not had a discovery as to what those facts are, but
okay.
FDA advised it was becoming more common for these veterinary authorization prescription foods to be sold at retail and to be advertised direct to consumers.
Right.
Was at the time that PetSmart Banfield began placing it as a special subgroup in its retail stores. It certainly could have was purchased by through veterinarians before then.
Okay, so the restraint of trade claim is that they agreed to require this prescription, not that they somehow fixed the price.
Well, they agreed to require the prescription to allow them to artificially inflate the price.
Inflate the price, but not for a particular price.
No, for inflated.
To generally inflate the price by this prescription policy. Okay.
Yes, Your Honor. Yes, Your Honor.
You can go ahead.
Thank you. I wanted to read just a quick point from the Moore opinion, which is the California Appellate Court, and talking about the term prescription pet food. The court said, common sense dictates that a product that requires a prescription may be considered a medicine that involves a drug or a controlled substance. Cites to Merriam-Webster's dictionary. Now, this conforms to general understandings of prescription drugs for humans and pets, Moreover, the brand name of prescription pet food itself could be misleading. A reasonable consumer being told about prescription pet food may be surprised to learn that there are no drugs or controlled ingredients in the pet food by nature of the brand names, like prescription diet. I'd like to reserve the rest of my time for rebuttal if I could.
Okay, thank you, Ms. Johnson.
Thank you.
Ms. Dubin, you may proceed.
Good morning, and may it please the court. Plaintiff's KCPA claim fails for 2 reasons. As a matter of law, she can't show that Hill's conduct was deceptive, and she can't show a causal connection between Hill's conduct and her purchase. I'll start there and then turn to the antitrust claims if we have time. At its core, this case is about whether Hill's can require customers to consult with an expert before purchasing therapeutic pet food. You heard from opposing counsel that this requirement is deceptive, but this requirement is the opposite of deceptive. Consumer protection laws exist to protect consumers who lack information, who are left to their own devices to evaluate products. But here, plaintiff is invoking that law to challenge a practice that is information enhancing. Hill's allows customers to purchase this pet food only if the customer first communicates with and obtains individual authorization from the most knowledgeable expert around, the vet charged with the care of the pet. That gatekeeping requirement, which is exactly what the FDA strongly encourages as the mechanism to ensure that consumers are not confused, isn't unlawful.
Okay, can I stop you right there? First is the FDA requirement to ensure that consumers aren't confused or misled, or is it to ensure that, well, at least if there's a veterinarian that's signing off on this, we can have some relief in the fact that a medical professional is going to have looked at this, so it's not going to do any harm?
Your Honor, the FDA's CPG is directly aimed at the question of consumer deception. And I think it's helpful if you look at volume 1, page 78 of the record, where the CPG talks about this directly. And it talks about that these therapeutic pet foods may not provide adequate daily nutrition if fed as a sole diet. That concern is reduced when such dog and cat foods are marketed only through and used in the direction of a licensed vet. The vet will discuss an animal's nutritional needs and make periodic assessments. Because these products have not been evaluated for safety efficacy, veterinary oversight is especially important to provide periodic assessment of how the animals reacting to the diet and to continue the product's use when warranted. That's a classic use of the vet to make sure that the pet's owners are not confused about the right way to use this. And the CPG also explains, and I think gives a specific example that's very helpful, which is the diabetes and insulin. Yeah, sure.
May I interrupt you for just a moment? I understand that the discussion with the veterinarian can provide guidance, but in this instance, it seems we are transcending mere guidance when these foods are being or necessitate a prescription in order for purchase. And in the case of PetSmart and Banfield, require an actual medical card. So how is that not going beyond a mere consultation into the realm of treatment?
So a couple of responses, Your Honor. First of all, it's exactly what the CPG encourages. And the CPG says that you should make available to the public this product only through a licensed vet. So you need some way of making sure that the vet performs that role as gatekeeper. The CPG isn't just suggesting, oh, you consult with the vet, you talk to the vet. It's saying you should only be able to purchase this product if the vet in fact authorizes you to do so. And that's exactly how Hill's had been distributing this pet food for decades before this, and it's what the CPG was affirming. I think Your Honor's question, though, also takes us to this sort of second point that plaintiffs are raising here, which is they're focusing on the word prescription, as opposed to whatever else you want to call this requirement, whether it's a permission slip, authorization, et cetera. And the word prescription can't save their claim that you can't talk to an expert. And I'll explain for 2 reasons. The first is that the word prescription isn't deceptive. What happened here is that the plaintiff went to a vet who recommended and authorized her to buy this specialty product, which cannot be purchased without authorization, consistent with FDA guidance. That's what we call in ordinary English a prescription. And that's what the same dictionary that opposing counsel cited defines it as ahead of the dictionary definition that she cited. a written directive for a therapeutic agent by a medical professional. There's no easy, natural, or ordinary word to describe the process of needing vet authorization other than prescription. Kansas law
Can I
does.
interrupt you for just a second? And I'm going to give you a hypothetical, and it's kind of long, and I'm going to read it because I had to write it out ahead of time to remember exactly the parameters of my hypothetical. And I want you to tell me if you believe this would be deceptive to the consumer. Okay. So suppose I decided to start a business selling enhanced water. Okay. I market my water as having ingredients that can increase your energy and allow you more endurance as you exercise. And people who have used my product attest that it gives them more energy. I have put a small amount of vitamin B12 in the water. B12 does have properties to increase energy. I go to various businesses that cater to outdoor enthusiasts, or say I go to the major gyms in the country, the big players in workout facilities. And I enter an agreement with them, and only them, that they will sell my product, my water, but only with a doctor's prescription. Okay, even though there's nothing in my water that would be regulated by the FDA, and no prescription is needed to buy water or B12, and I have simply combined the two. Okay. So I also get doctors that specialize in fitness to sell my water exclusively in their practices and give them a percentage of the sales. But again, they can only sell it with a prescription that they write. And I even give them a pre-filled out prescription pad to use to write the prescription for this water. A pad that they don't have to account for to regulatory agencies because no prescription is really required under law for this water anyway. It's kind of like double secret probation. No one's the wiser, no one's hurt, okay? So to increase this ruse that this is something really special, I put some doctors on staff at these workout facilities, and so they can give these prescriptions for this water on the spot. I charge 4 times as much for my water, and I call it prescription energy water. Now, as with all dietary supplements, the FDA doesn't regulate them, but it does suggest you consult with a healthcare professional before using any dietary supplement, because some supplements contain ingredients, and this is on the FDA website, that may have strong biological effects, and they may not be safe for everyone. Doctors have no problem writing the script because you don't have to have a script for it anyway under the law. So they have no liability related to prescribing it. And they get to be exclusive providers of my prescription water that consumers are now so anxious to get because this water is so good, doctors are prescribing it. So do you believe that is deceptive to consumers to market my water as prescription water and require a doctor, if anybody's going to sell my water, they've got to get a doctor's prescription or have a setup to allow for a doctor's prescription before they sell it? Do you think that's deceptive?
So, Your Honor, medical human food and pet food are different.
In this case, they're not. In this case, they're not, because I don't have anything in my water. I believe your client is saying there is nothing in Hill's Science diet that requires FDA approval. Is that correct?
Correct, Your Honor.
Okay.
But it's a veterinary diet.
Yeah, but how is that different than this scenario? Go ahead.
Your Honor, it's different than this scenario because this is a specialty therapeutic pet food that helps pets. It helps sick pets, and like Theo, who had a skin allergy. But it is not good for pets who don't need it. For pets who, it's not like your enhanced water example where everyone could drink it and it has no specific therapeutic uses for particular animals. And the way we know it's different is because the FDA directly considered this. Hills have been selling this food for decades. Then a couple of new entrants on the market started selling the food direct to consumers. So in your example, it would be like someone coming in and selling your enhanced water direct to consumers. The FDA then at that point came in and said, we are uncomfortable with that. We do not think that is good for pets. We do not think that is good for the market. What you should do to avoid any regulatory enforcement action against you is to make sure that this food is only sold through a licensed veterinarian or with veterinarian authorization. That's what the FDA wanted in this case. That's what the FDA wanted in this market. And I think that at the end of the day, this case comes down to a legal question, which is whether you think there's any room in Kansas for specialty pet food that plays an important dietary role in supporting pets in varying stages of health, and which, as the FDA says, is better, safer, and more effective when used after individual authorization with a medical professional rather than sold directly to consumers.
Mhm.
Well, even if we answered yes to that question, that we think it's a good idea, that doesn't necessarily mean that using the term prescription is not misleading. It might be that if it's a therapeutic product, great, but that doesn't seem to defeat all the plaintiff's claims in this case.
Sure, and so I really do want to separate the two things. I took the Chief Judge's question to be about the practice of requiring that authorization. I think Judge Gardner, your question, Judge Isherwood's earlier touched on the word prescription. As I mentioned earlier, the word prescription is an 100% accurate term for the process of a written directive for a therapeutic agent. And that's exactly how it's being used here. It's not just being used in accordance with its ordinary meaning, it's being used in a context that makes exactly clear that right now you are being authorized by your vet to buy this product in the context of the expert that the FDA wanted involved. But even if you disagreed with me and thought the word prescription is a problem, it wouldn't matter here because there's a big problem with plaintiff's reliance on the word prescription diet. And that's that she doesn't allege that she saw the prescription diet labeling or any packaging before she made her purchase decision. And Kansas courts consistently dismiss KCBA claims where the plaintiff doesn't allege that she saw the prescription diet label or branding before purchase.
But
I don't
doesn't Kansas Consumer Protection Act say you don't have to be misled?
The Kansas Consumer Protection Act says that for a suit brought by the AG, you don't have to establish that the consumer was misled, but it also says that a consumer bringing a private cause of action for damages must be aggrieved. And the Court of Appeals interpreted that in Finstad, and this court talked about it in Schneider. And what that means is that there has to be a causal connection between the deceptive practice and the loss. And here, that's what plaintiff can't show. She can't show, or she doesn't allege that she saw the prescription diet labeling or any packaging. And I don't think that's an accident here. The plaintiff's class consists of all purchasers of this food, not only those purchasers who saw the trade name first. That would be a different case. And if you go through the petition, and the district court did so and analyze it in detail, the petition is challenging this requirement of vet authorization. It talks about imposing a condition precedent. It talks about the condition precedent being an important step in buying this food. What the petition is concerned about is this sort of velvet rope theory that someone who comes to a product that they have to get through a vet is going to think that it's a product of something else. That's the practice. Whatever you call it, the practice of holding this only allowing you to buy it with expert consultation, that's about the practice, not the word prescription.
Let me ask you one other question while we're talking about the word prescription. The opposing counsel has cited the Ninth Circuit Moore case, which defined prescription differently. Do you have any legal authority that defines prescription as you have done?
Yes, Your Honor. It's actually the same definition. The court in Moore is quoting the Merriam-Webster dictionary definition 4B, I'm sorry. We're talking about dictionary definition 4A, which is a written directive for a therapeutic agent. And there's lots of other dictionary definitions that will give you the same meaning because that's what it means in ordinary English. I've been struggling as I've been thinking about this case to think of another word that you would use to describe what you actually in fact need here. If you need to tell consumers that they in fact need to go to a vet and get permission to purchase this product, that is what we call in common English a prescription.
Well, one of the things that Judge Wanell mentioned in his decision was, yeah, but if you want to start a particular diet program, you're always told you should consult with your physician before entering into any of this. Consulting with your physician about whether this is going to hurt or help my pet seems to be very different than requiring that, at least to the consumer, than the thought that I have to have a prescription for this item. So, I agree. It doesn't seem like it would be a problem if you said this dog food helps your pet, is a good diet, a good mix of food for a pet that has this particular ailment. It gives them the nutrition they need for this ailment. So we recommend, and my vet recommends that for this ailment, this product is probably the best. But to go the next step and say you have to have a prescription for it seems very different.
So Your Honor, in your scenario where all you had to do was go talk to a vet about it, and then you could go purchase this food anywhere, at a supermarket, anywhere else, the company would not be in compliance with the CPG. It would be in violation of the first factor, the CPG, and it would be subjecting itself to regulatory enforcement. That's why the companies are—
Because you're viewing this compliance policy as a mandatory, that as long as I do this, I don't have any legal liability for anything I say. As long as I get a doctor's approval, then this prevents me from having any legal liability.
Two sort of points that, Your Honor. So in terms of it obviously doesn't protect you from anything you say in the world, right? No CPG could do that. What the CPG does is very important here. The CPG, I think you heard from opposing counsel that it's, an internal document, or doesn't have any force here. The way the FDA uses CPGs is as a published regulatory enforcement paradigm that talks to the industry. And you can look at this in the manual of the CPGs. You can look at this as 21 CFR 10.115E. The CPG is meant to help industry understand how the FDA is thinking about regulatory enforcement. No reasonable in-house counsel would ignore the CPG. So what the CPG tells you is that vet authorization requirement, whatever you call that, right? You can call that whatever you want, but requiring vet authorization, and it's more, I would encourage you to look at the first CPG factor. It is more than just go talk to a vet. It is only making the product available to the public through a vet, right? They want vets to be gatekeepers. That is exactly what the CPG is about. What that does is tell you that under Kansas law, a company shouldn't be put in the position of either complying with the CPG and its mandatory condition for regulatory forbearance, or complying with Kansas deception law. What plaintiff's case would mean is that the company could only sell these products directly to consumers, right? Exactly what the CPG was passed to stop. That's the sort of problem with their case. I also wanted to briefly address a few things that you talked about with opposing counsel. She mentioned 62A of the complaint and suggested that there are disease treatment claims.
You have a couple more minutes because we have taken up some of your time. Go ahead.
Thank you very much. She mentioned that 62A talks about disease treatment claims, but if you look at the claims on Hill's labels, they are things like weight management, dental care, etc. These are classic structure function claims to support the structure or the function of the body. And these are exactly the sort of claims that are made by foods, not by drugs. And it's very important as a therapeutic effect. One other thing that I wanted to mention just on the antitrust claims very briefly is that the court in Moore did address them and rejected them in a separate decision, as opposing counsel mentioned. And that's because plaintiffs have not made out a claim of a conspiracy in any way, and haven't alleged direct evidence, and they haven't alleged parallel conduct or plus factors. And they also cannot make out the substantive conspiracies they've alleged on either fixed price fixing or monopolies.
Thank you.
Thank you very much.
Ms. Johnson, you have 3 minutes.
Thank you, Your Honor. The FDA has not established that these prescription pet foods help sick pets, as opposing counsel claims. And in fact, the FDA says that they are misbranded, adulterated, and technically their sale in interstate commerce is not allowed. Veterinary oversight is not the same as a prescription pad, as you pointed out, Chief Judge Arnold Berger. When a veterinarian takes that prescription pad, or just tells somebody, I want your dog to take this prescription food, there is an implication in there. And you can cite different dictionary meanings, but on this standard, when every benefit of the doubt should go to the plaintiff, the fact that we contend, and I believe the term does carry with it an indication that the food itself has an approval that it doesn't have, that supplier has an approval it doesn't have, that it's a particular standard or quality of grade, and that the benefits of this food have been proven or otherwise substantiated. None of that is the case here, and those are plain violations, per se violations of the KCPA. Quickly, as to causation, the vet can't be an intervening cause here when the prescription mandate is coming straight from Hills. The vet didn't say, I want you to take this special food under my supervision, my veterinary authorization. The vet said, this is prescription pet food, and I believe your dog needs it. This is akin, I think, to the case, it was a case in the District of Kansas, the Universal Service Fund case involving, back when we all had long distance plans. It involved a universal service fee that went out on bills to all consumers. And it was listed, Sprint, who was the defendant in this KCPA claim, had, the contention was that they had misrepresented this USF as a legally required, pass-through by listing it as a tax or regulatory charge, when in reality, some of that money was being retained by Sprint. Now, if that is stating a claim under the KCPA, clearly viewing the facts and all inferences in the plaintiff's favor herein, that claim is fully alleged by the plaintiff in this case, and we respectfully request that the dismissal be overturned by this court.
Ms. Johnson, Ms. Johnson, I have a quick question for you. I wanted to talk about the collusion issue really quickly. Help me understand how that is not a conclusory allegation. I understand inferences, but how is this not conclusory and pure speculation on your client's part?
You're talking about the antitrust, the collusion allegations?
Yes.
I will agree those are more difficult claims here. And we are, having lost those in California, we have a more difficult row here. But, the fact is, I think it may be, you said conclusory, but the fact is that the three manufacturers that we have identified control and are alleged to control more than 95% of the market. And we've alleged that Banfield, PetSmart keep the prescription pet food products or the veterinary authorized prescription pet food products of others out of those retail stores. And they did begin allowing their sales through the website, I believe, but that was only after this litigation began. So
are you equating their absence from the store with exclusion from the store, from these other products? Their mere absence means they must necessarily be being excluded by Hills?
Your Honor, I hear your point that there could be other reasons for that. However, we haven't had any discovery at this point. We're looking at the pleadings, and that is what has been alleged.
Thank you. Any more questions from the panel? Okay, thank you very much, Ms. Johnson, Ms. Dubin. Very well argued case, extensive briefs. We'll take our time to go through this, and as soon as possible, we'll get out a written opinion. Okay, thank you very much.
Thank you, Your Honor.
Mm-hmm.